There are about 34 states that have federally facilitated exchanges, and individuals who signed up for health insurance coverage on those exchanges, about 90% of them received subsidies to help that coverage become more affordable. Hi, I'm Barbara Zabawa. I own the Center for Health Law Equity, which is my own law firm, and I practice healthcare law and wellness law, and my clients are healthcare providers, insurers, wellness organizations. At issue in the King v. Burwell case was whether those individuals in the federal exchanges were eligible for those subsidies, because in the Affordable Care Act, the statutory language says subsidies will be available for participants in exchanges established by the state. And because those federally facilitated marketplaces were not established by the state, the challengers to this provision argued that subsidies should not be available to those federally facilitated marketplace participants. Chief Justice Roberts authored the opinion of the court. It was a 6-3 decision, and Chief Justice Roberts decided that subsidies would be available in all exchanges, so both state and federally operated exchanges would have subsidies available to those participants. And the impact of that case is, of course, all those people, the 90% people who qualified for those subsidies in the federally facilitated exchanges will now continue to have those subsidies, making health insurance more affordable. The fear was that a decision in the opposite direction would make insurance for all those millions of people. I think there's about 6.4 million people nationally ineligible for the subsidies, and therefore the insurance would be unaffordable, and many more people would now be uninsured, and that will not happen now. Some of the commentary about the decision itself has been really interesting. There was an issue I know raised in oral arguments about whether the challengers had standing, but the court didn't even discuss any jurisdictional issues. They bypassed that, as well as bypassing giving deference to the Internal Revenue Service, which has been the agency responsible for interpreting the Affordable Care Act to extend subsidies to both state and federal exchanges. And the court decided that Congress did not authorize the Internal Revenue Service, an agency that has no health policy expertise, to decide what the Congress meant by an exchange established by the state, and so decided, as the Supreme Court, to interpret that phrase itself. And the outcome of that, according to some of the commentary, is that it now solidifies the subsidy availability in federally operated exchanges, regardless of who is in the White House. So for the next administration, there may have been a possibility that the Internal Revenue Service may have interpreted that phrase differently to no longer allow subsidies in federally operated exchanges. With the Supreme Court now interpreting that language to mean and to encompass both federal and state exchanges, now a future administration would be unable to undo that interpretation.